Welcome to Judge's Corner. My name is Judge Matthew Sabaugh, and I'm joined today by Kelly Beidelman. She's the managing attorney for the Legal Aid and Defenders Association of Macomb and Oakland County. And today we're going to be talking about a specific area of law which is in the district court, and that is small claims. Welcome, Kelly.
Thank you.
Thanks for being here today. Could you give a brief introduction to the viewers? What is small claims?
All right. Small claims court is a means of resolving a dispute of under $5,000. And it's informal and it's quick.
And the idea is to give ordinary people the ability to have their case heard without having to go out and hire an attorney. Is that right?
Exactly. Small claims, if you agree to submit to the jurisdiction of small claims court, you're giving up your right to an attorney, your right to appeal the district court's decision, and also right to a jury.
And I understand that the Legal Aid and Defenders Association actually has a program that they've put together which you're presenting in local communities?
Yes. Throughout the Tri-County area, we present a small claims workshop in Wayne County, Oakland County, and Macomb County, and we rotate them every 3 months. We typically do them at the local libraries throughout the communities.
So if a person is interested, believes they may have a case against someone that they want to file in small claims court, I guess the first question they might want to know is, what type of case can they file suit for in small claims?
Basically a money type case. You're suing for money in small claims. The small claims court doesn't have jurisdiction to make people do something or to give relief other than money. And again, it does have to be less than $5,000. That limit was recently changed from $3,000, and it's going to be going up in increments every 3 years until it reaches, I think, $15,000 in the year 2025.
Now, there's also something that we're familiar with called the mini tort law.
Yes.
How does that apply in small claims?
Basically, if you're involved in a car accident, the drivers have no fault insurance, but the person at fault could be liable to pay the deductible of the other driver. Most often, those claims are handled between the insurance companies, but in the event that the insurance company or the person didn't have insurance or what have you, you can sue them for up to $1,000. That limit was also recently just changed. It was $500.
I see. So a person feels they have a claim against someone. They want to file a suit in small claims. What do they do?
Well, they first file an affidavit of small claims where they list themselves as the plaintiff, the person they're suing as the defendant. They have to know the amount of their claim, and they can also ask to recover their court cost if they win their small claims lawsuit. And then they have to list the reason for their claim. It is up to the litigant to find out where the defendant is. The court will not help a person locate a defendant.
And by finding out where they are, obviously they have to serve them with the lawsuit, correct?
Yes. In our justice system, if you are suing somebody, they must be personally notified so that they have the opportunity to defend it.
How does we'll call them the plaintiff in this case, the person filing the lawsuit, how do they know where to file their claim?
The law says that they file it where the defendant resides, or if the defendant is a business, where the business does business, or they can also sue where the cause of action arose. So let's say that they do business with somebody that lives in Roseville, they live in Warren, the person comes to their home in Warren and does home repair, and they want to sue them. They can sue them either in Roseville, where the defendant resides, or they can sue them in their own jurisdiction because that's where the cause of action arose.
So once the defendant has been served with a copy of the complaint, what happens next?
The court sets up a hearing. When you initially file your claim, you're typically giving a hearing about 30 days out. And then you have that opportunity to serve the defendant personally, and then you come for your court date.
In Warren, in the 37th District Court, Warren and Centerline, we also have another step in between the filing and the actual hearing, and that is a mediation hearing, where we have representatives from the Resolution Center from Mount Clemens actually are here in the building. meet with the litigants in small claims cases. And we found it's been very successful in that a lot of times the parties can come to a meeting of the minds and agree on a settlement. Is that one of the things that you talk about when you talk to litigants?
Yes, we do. Some courts offer that service, and it's a wonderful service because the litigants, that might be the first time they actually sit down and talk. And oftentimes they can resolve it, and they don't have to resolve it by money. They can resolve it in other creative ways, whatever way that they decide to, because you know when you go to court, you never know if you're going to win or lose. So many courts do offer the services of a mediator. You come in for your hearing, you first meet with the mediator, see if you can resolve it. If you can't, then you have your hearing in front of a judge. Other courts use the services of a magistrate. And a magistrate is an attorney appointed by the court to hear small claims matters or traffic tickets. And the purpose, of course, is to relieve the district court judge from a heavy docket. But if your matter is heard in small claims court by a magistrate, you do have the right to appeal that decision within 7 days to your district court judge. Once the district court judge hears your small claims matter, or if the district court judge initially hears the small claims matter, as you do here in your court in Warren, then there is no right to appeal from there.
And in the 37th District Court, the small claims division is essentially a division of the civil division. It's a civil case. What if someone is sued, as on the other side of the small claims case, gets sued by someone and they want to hire an attorney? Are they forbidden from hiring an attorney?
If they agree to small claims jurisdiction, yes, they're forbidden from hiring an attorney because attorneys are not allowed to represent people in small claims court. So what they can do if they want representation is simply come to the court and file a demand and order for removal to the district court. That way you can have an attorney, you have the right to appeal, you have the right to request a jury trial. But the plaintiff also has that right to do that. So let's say I file a small claims action and it gets closer to the hearing date and I think, you know, I guess I really do want to have an attorney, or maybe I do want to have a jury trial. I can also ask that it be removed to district court.
What type of advice do you give to plaintiffs in small claims cases, I suppose, or even defendants, as far as the hearing? Right. What's expected of them? As a judge, I have to apply the rules of evidence. It's still a civil case. It's a small claims case, but they're not attorneys. These are ordinary people. How do you give them advice on that?
We give a lot of advice. For instance, you know, have your witnesses available, have your exhibits all lined up. Think about what you're going to say, even if you have to write down the points that you need to make. That's absolutely fine to have notes. But you want to have a story. Sometimes it's good to tell your story chronologically. Certainly you want to dress appropriately. You want to be on time. You want to address the court as your honor. You don't want to talk when other people are talking. You want to be, you know, certainly you're not going to be held strictly to the rules of evidence because you are in small claims. It is more informal. But it is important to bring witnesses and bring exhibits so that you have the information you need for your hearing. And always be civil. No yelling, no arguing, no swearing. It is a court proceeding. The plaintiff does get the opportunity to go first to tell their story. Then the defendant gets the opportunity to talk. And then the plaintiff will get an opportunity to talk again after that to rebut anything that the defendant says.
The legal term we use is the burden of proof. In a small claims case, who has the burden of proof? Who has to prove the case?
It would be the plaintiff.
And the standard is preponderance of the evidence.
Yes. Yes.
Explain that a little bit to the viewers, because I think even lawyers sometimes have a vague understanding of that.
All right. Well, a preponderance of the evidence is just a small tipping of the scales of justice. The plaintiff has proved their case by a preponderance of the evidence, so the judge believes, you know, that they've set forth a good legal argument. If you sue somebody for fraud, that's a higher standard of proof. It's a more tipping of the scales by clear and convincing evidence. And then finally, as we see in murder trials and criminal trials, that's beyond a reasonable doubt, which is a huge tipping of the scales of justice.
when a client or prospective client approaches your office seeking a legal aid in a small claims case, are there cases where you will recommend that they have an attorney to represent them rather than it be filing in small claims?
Oh, definitely. Some cases, well, certainly some cases the small claims court doesn't have jurisdiction, but other cases there might be some more legal arguments, sophisticated legal arguments that they would have to present, where it might be better to take that claim to district court. And certainly if their damages are more than $5,000, they should take the claim to district court, because district court can handle an action that's up to $25,000.
And once the judge makes their final ruling at a small claims hearing, no one can appeal that ruling, correct?
That's correct.
At the next segment, we're going to talk about what to do when you get that judgment in small claims cases. We'll be right back. This is Judge Sabaugh with Judge's Corner and my special guest, Kelly Beitelman.
There are a million places you'd never consider texting. So why would you do it while driving? Leave risky driving to the professionals. Stop the texts, and together we can stop the wrecks.
You sure you don't want some? It's chamomile. Listen, you are extremely terrifying. Just the scariest undead subhuman thing on TV, and I really mean that. But I am worried that you could give my kids nightmares if they see you, so I'm gonna have to block you. So that's it. Oh, and tell the zombies they're blocked too.
Welcome back to Judge's Corner. This is Judge Matthew Sabaugh, and my guest today is Kelly Beitelman from the Legal Aid and Defenders Association, representing Macomb and Oakland counties. Kelly, we've been talking about small claims actions, and when a person files suit in small claims court, their goal is to win, is to get a judgment. Let's say they have their hearing, they win their case, and they now have the judgment in hand that the defendant owes them so much in damages, up to $5,000. What is the next step from the plaintiff's perspective?
From the plaintiff's perspective, they have to wait 21 days after the judgment has been entered before they can start any collection activity. And there's various ways that you can collect on a debt. You can do a wage garnishment, a bank account garnishment, a state income tax refund intercept, or an execution against property. If you know where your defendant works or where they bank, that makes it a little easier to start collection activity. If you don't, the first step that you want to take is to ask the court for a subpoena for a debtor's exam, so you can bring the defendant into the court to testify as to their assets and their income in order to help you collect on your judgment.
Is this something that a person that's a non-lawyer can do on their own, do you find, or do you find that they require legal assistance to do that?
No, they can certainly do it on their own, and it is set up so that folks can attempt to collect on a judgment on their own. So they could start with the debtor's examination, where they subpoena the defendant to come in to testify as to their assets. The judge has to sign the subpoena, and they can ask for the defendant to bring items such as titles to property, deeds to property, titles to vehicle, their bank account information, their pay stubs, anything that's going to help the creditor determine how they're going to be able to collect on the judgment that they have. And the judgment, I should add, in small claims court is good for 6 years. A district court or circuit court judgment is good for 10 years and can be renewed for an additional 10 years. But in small claims court, the judgment is good for 6 years. So you have to collect the judgment within that time frame. If you're not able to, it expires and you're out of luck.
Do you know if that judgment is something that would be entered on the defendant's credit history?
Yes. Typically, all judgments are on credit reports. The credit reporting agencies pick those up. Judgments can stay on a credit report for 10 years.
So from the defendant's perspective, if they get sued in small claims court, they get a judgment against them, what can they do to kind of to protect the assets they do have and also try to pay this debt back in a timely manner?
Well, if they have wages, they may want to think about asking the court for a motion for installment payment order so that they can make monthly payments, and that will protect their wages from being garnished. If you garnish a defendant's wages, you're entitled to garnish 25% of their net wages each pay period. So to stop that wage garnishment, simply file a motion for installment payment. The courts will usually allow you to work out, a reasonable payment. And if the creditor doesn't object to the amount that's proposed, there doesn't even have to be a hearing. Or you can contact the creditor or the plaintiff that has sued you to try and work some type of payment arrangement whereby they won't take any other collection activity as long as you're making payments. But the installment payment order only protects wage garnishments. It doesn't protect a creditor from coming after a person for their bank account, their state tax intercept, or doing an execution against property.
Don't the parties always have the right, once the judgment's entered, to work out a payment plan on their own?
Yes.
Without it being an order of the court?
Yes.
Is that something that you would advise your clients to do or not?
Definitely. Whether you're the plaintiff or the defendant, at the conclusion of the small claims hearing, you know who won, and at that point, you want to start discussing how it's going to be paid. It's so much easier to make payment arrangements, to make a monthly payment, than to have these other things happen. We know that if persons get their bank account garnished, they probably have some outstanding checks and things that are written, and it just, the effect of that garnishment can result in a lot of fees and things. So, don't bury your head in the sand. You have a judgment against you. Take some action and see what you can do to get it paid. And once it is fully paid, the plaintiff has to file a satisfaction of judgment with the court to let the court know that it has been paid in full.
And I always recommend this to people because I've seen it done in small claims where they don't get receipts or they pay in cash judgments and it's just not able to be proven in court without a receipt, without a record, a returned check. That's critical because in the courtroom, obviously, we rule based on the evidence.
Yes.
Now, tell me, you run this program all over the community. What types of questions are you finding that people have? What areas are they most interested when it comes to small claims cases?
I think mostly how to collect once they won. Because that's, it's hard. People don't know what their rights are, how they can collect on a judgment, and that there's all different avenues of collection. But we get folks in our clinics from all walks of life, all economic situations, that just want to avail themselves of the small claims process because they've been wronged and they want to sue somebody. So they'll come in. Other questions are, how long do I have to sue somebody? What's the statute of limitations? Typically in small claims court, most people are suing for a breach of contract. You agree to do something, the other side agrees something, and it doesn't happen. And those types of claims need to be brought within 6 years. But those are the most typical claims that we see in small claims court.
This is touching on a different area, but a lot of the cases that, as a judge, I see in the small claims court are contract cases and consumer contract cases where someone gets their car repaired and they're not happy with the results, or someone buys a car and they're not happy with the condition of the car. Are there any other agencies that you refer to people with those types of automotive claims?
Yes, the Attorney General's office has a consumer protection division, and you can certainly contact them just as well as the Better Business Bureau. But if you contact the Attorney General, they do have an auto repair division where they might be able to assist you, and certainly mechanics are licensed. So if you have a complaint against a mechanic or any profession in which there's a license, you can make a complaint with the Licensing Bureau.
And that also would apply in cases of home repair contractors. A lot of
Yes.
the cases involve home repairs and remodeling, and those are also licensed professions, correct?
Exactly, yes.
Do you find that now that the small claims jurisdictional limits have increased, we're finding the 37th District Court, we're having many more filings. Are you finding this is true around the region and around the state?
I think so. I think so. And I think it was, it's a good idea to increase it because there's a lot of people that can't afford attorneys and they have a claim, that was more than $3,000. And it's still a low enough number that they're able to represent themselves. But I expected that more people were going to be able to avail themselves of representing themselves due to the limit being increased.
And one of the interesting things about the law is that it does allow you to sue a corporation in small claims, correct?
Yes, yes.
But at any time, well, during the preliminary stages of the action, any party can ask to have the case removed to the General Civil Division with an attorney.
Yes,
correct?
definitely. Yes. Yeah, both parties have to agree to the jurisdiction of the small claims court because you are giving up those fundamental rights.
Very good. Is there anything you could add to our viewers to help them navigate their way through the waters of small claims?
Well, you can visit our website at www.ladadetroit.org. The LADA stands for Legal Aid and Defender Association. If you visit our website, you will find where we are doing our small claims workshops. We also offer other community workshops in areas such as landlord-tenant, rights and responsibilities, expungement clinics, foreclosure workshops. So we offer a wide variety. And if you are interested in opening a file for specific legal advice, you can contact us at our toll-free number of 1-877-964-4700.
Kelly Beidelman from the Macomb, Oakland Legal Aid and Defenders Association, thank you very much for your time. It's been very informative. Thanks for being a guest.
Thank you very much.
Thank you, everyone, for another edition of Judge's Corner. This is Judge Matthew Sabaugh.